Your Honor, may, oh.
No. Court calls the case. People versus Jeffrey Bloom.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you
Man,
go.
I was gonna try to get you. I was gonna try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least
And
I'm
you
not.
said,
At least I'm not driving with a suspended license.
I have no comment.
Okay. Two times now I've let it go. Remember?
Let what
Last
go?
time I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that, I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay, no, not last time. Okay. Your Honor, this case, assault and battery case has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any, there's a lot missing from discovery still. Remember, since October, we've.
No, I remember you
Tooth and
mentioning
nail.
it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why. Listen, Mr. Bernstein. Which discovery referencing, Jeff?
Hospital report that Deputy Sawyering says there was a hospital report. There was, I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report.
Mr. Bloom.
Okay, I'll let it go.
Because you keep asking me questions you know I can't necessarily answer.
Okay. Let me get on with the real stuff.
Oh, okay.
Per transcripts.
Transcripts
No, I still haven't received the transcripts.
of what?
3/6. Remember I asked for the transcripts from 3/6? I still haven't received transcripts from 3/6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney. Tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants. I have individuals that I work for that are professionals. So I don't know what you have, but
I've got
I don't
professional
have that.
real.
But go ahead.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing, and someone in my office we did a transcription of it for Jeff. But I think what he wants me to request is an actual transcript, and I just didn't.
Well, and so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen. So,
Thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff's 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy says.
hold on a second. What are you reading to me right
now? Something that I want to state on record, Your Honor.
No, but what you're obviously stating what somebody else said. I'm just trying to figure out where it's coming.
You said.
On the 24th of.
No, on 10-4 of 22.
In this case?
No, you stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority or authenticity. and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be
Okay,
in
well,
regard to your
I'm
other
trying to
matter
put-
because
I'm
this
trying to
didn't
put
start.
canons.
No, stop. This case didn't start until 10/18. So if you're referring
Okay, I'm
to a
past that.
record from another case,
Then I'm past that.
then you're past what?
I'm past the other case. Here we go. This is this case. Canon 2, Canon 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court. It is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No, that was regarding your dental.
Yes.
Yeah,
Yes,
has
that was a
nothing to
motion
do
we
with-
filed. Your
No,
Honor.
but that has nothing to do with the
But
case.
I mentioned that on
And
other days you did
but
that.
Mr. Bloom, no, Mr. Bloom,
You don't
because
wanna
if you're
hear it.
going to, you don't want to hear, I don't. Because what
know.
you're saying is incorrect.
Okay.
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
There were other
But-
matters you did the same thing, Your Honor.
Bye.
I'm not
Goodbye.
contacting your
Goodbye.
commission.
Goodbye,
I'm not
Mr. Bloom. Goodbye. Thank you. Have a great day. Take care.
We'll contact the senior commission.
Have fun. That went south.
It's like an orchestra there. Of one voice.
Yeah.
Quietly leave, Your Honor.
Mr. Bernstein, that is apparently all your fault. No, I'll get you the next time around. All right, talk to you. Yes, sir. That's exactly what they said.
They did not, Your Honor. They said that he knew where we moved.
Mr. Alice. Court does call the case, James Semenek versus Travis Ackerman. And Nikki Meltzer. Counsel, state your appearance.
For the record, Tom Ellis appearing on behalf of the plaintiff and president of the court of the honor.
Your names?
Travis Ackerman.
All right. You folks tried to resolve this matter or no? We're just gonna go to trial. Pardon?
We attempted this weekend. And we did not come to a resolution.
How close were the parties before we go into this?
Not very close, sir.
Mr. Ellis, you'd agree with that?
Yes, Your Honor. The defendants do not feel that they owe any money.
On this matter, then, this is the date and time set for trial on the Semenek matter. You ready to proceed?
Yes, Your Honor.
All right. Go ahead.
Your Honor, we have filed a motion to amend our complaint to include a complaint for damages and, I received no response from the defendant.
When was the motion filed?
You can go yesterday.
You guys get a copy?
It was addressed on May 21st.
I don't see a copy of a motion.
I can approach the bench and give a copy.
Do you see it in our thing that it was filed? You do? Yeah.
I have a note on May 20th, plaintiff submitted the motion to, it may have been filed in Saline. I need to reach out to the team.
Hmm?
Do you need me to reach out to obtain that?
I've got one in front of me. When did you guys get a copy of this?
It was dated, May 21st, 2024.
Say a few days
A
after
few
that.
days after that, yeah.
And what?
Just before heading into Memorial Day weekend. This-
21st?
Yeah, this was dated, May 21st.
For what date did you, the postmark?
This
What is that?
Postmark on May 21st, right here is the date that it was sent out.
So this is raising issues that they're entitled to answer regarding the security deposit.
Well, the lease provides that the security.
It doesn't matter what the lease is. I'm talking procedurally. You're raising claims regarding the security deposit at this late stage.
Well, they didn't leave a forwarding address, Your Honor.
Well, but that would precisely my point. They would be in, you haven't alleged that they haven't in this alleged amended complaint. You're just alleging a claim against the security deposit. Because I think as we were here at the last hearing, when we were talking briefly about it, they had indicated that they had provided a forwarding address.
I do not believe that's what they said. I believe
That is exactly what, is that what you said?
Yes, sir.
Your Honor,
No, I don't, just answer my question.
yes, sir.
That's exactly what they said.
They did not, Your Honor. They said that he knew where we moved.
Mr. Alice, they said it the last time. I just said it. I asked them to verify that my recollection of what they said is correct. If you have a dispute regarding the facts, fine. But if you're telling me that my recollection is incorrect, you're wrong. They said it. You may disagree. That's fine, but that's an element of any claim against a security deposit, which is precisely what I'm saying. Procedurally, this is a problem. They're entitled to answer, first of all, the motion to amend, and this is the procedural problem. They're entitled to answer the motion to amend. They haven't been provided. Was this mailed to them?
Yes.
You know, under the court rules, that's not enough time. You can't mail it. Says on the 17th. They don't get it till then, so they're entitled to answer the motion, and then they'd be entitled to answer the complaint if I were to allow them it to proceed. Folks, do you know what you want to do on the motion?
Sure, I'll answer that, sir.
That was an unfair question. Folks, do me a favor. Can you look at that amended complaint for me? And look at paragraph 3. You see the numbers that are there? All right. Without telling me why, because you don't, I'm not sure what I'm going to do with this yet. Are you disputing the electricity?
It's the electricity.
The electricity amount?
We had no collection of that electricity until the last hearing. So we had no opportunity to even pay Mr. Salmon back for that.
Okay, but
We won't dis-
let me,
I don't have a problem disputing that.
pardon?
I have no problem disputing that. That's fine.
You have no problem disputing it, or you
Not
have no problem with that amount? Okay,
if we hear.
that's fine. That's fine. The $2,400 in rent, are you disputing that?
Yes.
The propane, which we talked about, is obviously in dispute. And as I recall, at the end of the hearing, you're disputing the paint damage. Mr. Ellis, why should I allow this amendment at this late date?
Pardon me, Your Honor?
Why should I allow this amended complaint? Because it raises new claims.
Well, I thought since they did not answer the complaint, we have the absolute right to file an amended complaint without leave of the court. And they never answered the complaint.
So landlord-tenant proceeding, they can answer orally. Jeez, oh Pete. Know the procedure before we walk in, counsel. Court's gonna stand in recess. Sir, did you have a problem hearing?
Yes.
We have equipment that I'll have my staff provide to you so that you can hear the proceedings. Thank you.
All rise.
Court recalls the case of Samanek versus Okerman and Meltzer. All right. Couple of things here. First thing is the motion filed before the court. Usually leave is freely given to amend. This motion, the court could consider to be an untimely filing of the motion to amend the complaint, mainly because it doesn't. It changes the claims and makes a claim against the security deposit. There are certainly disputes, I guess, as to whether or not the Security Deposit Act has been complied with. Now, what that means, since you are operating in pro per, I would just indicate if it hasn't been complied with and wrongfully withheld, you could, under the Security Deposit Act, be entitled to double damages. That is one of the penalties under that act. Not saying that that's the case here, but it is certainly something that is within the realm of possibility. And that, quite frankly, would have been there absent the complaint, absent this motion to amend or the first amended complaint. So there's that. To try to get this matter resolved, and the court really is of two minds. One, given the timing of this and the setting for trial, I almost don't want to permit the amendment of the complaint. However, what would in effect happen is, in this court's mind, litigation regarding it would happen in any event, whether initiated from the defendants or whether initiated from the plaintiff. So my thought is to just get everything here and try to resolve it, however it gets resolved through trial. Having said that, the other problem then arises. So for you guys, that would be that unless you're objecting to the motion itself, you're then entitled to answer, which I would grant the motion. So let me make it easy. All right. So you don't spend your time with that. Then you're entitled to file an answer regarding the complaint. Okay. And basically it's an admit or denial or put forth your position regarding each of the allegations that's in this complaint. Now, having said that, the problem with the complaint as presented to the court is that the complaint would not survive a C8 motion. And that motion, frankly, on the face of the complaint, because it involves the Security Deposit Act, doesn't state the necessary claims regarding the Security Deposit Act. And I know I'm talking in legalese and I'm trying not to. Okay,
Now the judge breaks it down in plain terms. The complaint, as it stands, wouldn't even survive a basic legal challenge. That's huge. A C8 motion essentially says, even if everything you're claiming is true, you still haven't legally made a valid case. Think about that. It's not about evidence yet. It's about whether the argument is structured correctly on paper. And right now, it's not. But instead of shutting it down completely, the judge gives the plaintiff another chance to fix it. That's actually a fair and balanced approach, strict on rules, but still allowing correction.
a C8 motion basically says that on the face of the complaint, just looking at the complaint, that the complaint fails to state a claim upon which relief can be granted. The remedy for that is not dismissal necessarily of the complaint out of the gate. It is to permit amendment of the complaint. All right, got it so far? When a claim is made against the Security Deposit Act, there are certain, as I've indicated, certain requirements. Certain of those requirements must be pled, except to some very specific limitations within that act. So what I'm going to order is this. And folks, if you don't understand anything that I'm saying, just because this is an awkward posture for this case to be in, but just go ahead and ask me and I'll answer it. I'm allowing the complaint to be amended, but I'm directing that plaintiff must file a proper complaint that would, at least on its face, withstand a C8 motion and properly state a claim upon which relief could be granted under the Security Deposit Act. Plaintiff is to do that within 10 days. Defendant then has, I'm going to require a written answer this time. Defendant to file a written answer to the complaint within 10 days after receipt. Okay. So I need an amended complaint from the plaintiff 10 days out. Once you receive it, even if that 10 days hasn't expired, you need to answer within 10 days of receipt. Then adjourn the non-jury trial to, on the way out the last time, my understanding is there are nuptials that are to be occurring. So non-jury trial, June 18th, 9 a.m. Okay. And then we'll proceed at that point, have your witnesses, have your exhibits, have everything available on the 18th. We're just going to try to plow through as much as we can. All right. Any questions from either side?
No, Your Honor.
All right. And Mr. Semenek, did that help you? Okay. So next time when you come in, just ask for it and we'll make sure you get it. Okay. Thank you. All right. That does that.
This case is a perfect example of how courtroom battles aren't just about who's right. They're about who follows the process correctly. The plaintiff may have had a valid claim, but poor timing, weak filings, and procedural mistakes almost derailed everything. On the other hand, the defendant stayed consistent, dispute the claims, respond when required, and let the process play out. And the judge? He did exactly what a judge should do: enforce the rules, explain the law, and keep the case on track without letting chaos take over. Now I want to hear from you. Do you think the plaintiff deserved another chance? Or should the case have been shut down right there? If you found this breakdown helpful, make sure to hit that like button, drop your opinion in the comments, and don't forget to subscribe for more intense courtroom drama and legal breakdowns just like this.